He's very modest, but he is the Dean of our Parliament, and as he said, 43 years between the House of Commons and the Senate, and it's a privilege to serve there with him. So good morning, everyone, and thank you very much for being here today. Appreciate that. It is a privilege to be here to discuss our committee's interim report on court delays. And as my colleague Senator Baker mentioned, delays in criminal proceedings are a significant problem. Our committee has been exploring the many factors that contribute to these delays. For example, multiple adjournments and court appearances place tremendous strain on an already stretched system. An additional factor is the large volume of impaired driving cases. Statistics from 2013-2014 show that almost 40,000 cases involving impaired driving each year are creating a huge strain on our court system. As we continue our study, we will seek more efficient ways of dealing with these cases, such as administrative penalties. All governments will need to play a role to help minimize delays. Failure to act will lead to criminal charges being stayed, to the further traumatization of victims, and to a loss of public confidence in the Canadian justice system. During our hearings and fact-finding sessions, we explored alternative approaches that could help reduce court delays across the country. For example, our committee traveled to Halifax in May to learn more about that city's restorative justice programs. Another approach is the use of specialty courts, such as drug treatment or mental health courts, that emphasize rehabilitation and wellness. When used appropriately, we believe these courts would increase the fairness and efficiency of our justice system. Additionally, employing shadow courts, the practice of overbooking trial time to avoid empty courtrooms, has significantly increased court capacity in my home province of Saskatchewan. I saw the effectiveness of this practice during my time as Chief of Staff to Saskatchewan's Justice Minister. Technology is another tool that we can use to decrease delays in the justice system. Our committee explored how technological solutions can provide alternatives to counsel, victims, witnesses, and accused persons appearing in court for routine matters. Also, technology can help make the process of Crown disclosure of evidence more efficient. Based on what we have heard so far, our committee recommends the following. Number one, that the federal government work with the provinces, territories, and the judiciary to improve case management practices and reduce the number of unnecessary court appearances. Number two, that the federal government take immediate steps to ensure a more effective appointment system is put into place so that judicial vacancies are promptly filled. The committee notes that many judicial appointments go unfilled for lengthy periods of time. And I note that Chief Justice McLaughlin raised this very point this week. Number three, that the federal government work with the provinces and territories to explore the implementation of restorative justice programs, alternative courts, and shadow courts. Number four, invest in technology to modernize and increase the efficiency of criminal proceedings and to reduce the warehousing of accused people in remand centers. I look forward to our committee traveling across the country this fall. It will give us an opportunity to learn more about how we can meaningfully improve the administration of justice in Canada by finding out about best practices used in different provinces. I would now like to introduce my colleague, Senator Carignan, who will address the room en français. Senator Carignan is himself a lawyer and a former law professor. He has served as the leader of the government in the Senate and currently serves as the leader of the opposition in the Senate. Senator Carignan.